I won't call it a loophole, as gun grabbers like to call certain reasonable exceptions for law-abiding gun owners. We're the Armed Attorneys. Today we're talking about the worst places for reciprocity here in the United States if you're a law-abiding gun owner and traveling around. We're going to be talking about those states that don't recognize anyone's license or permit to carry a handgun. Some maybe exceptions to this rule. We got two different categories. But before we begin, show your support for the Second Amendment by hitting that like button and consider becoming a channel member. But to start things off, we have this list of states who do not like anyone's license or permit to carry a handgun and therefore offer no reciprocity to folks with a handgun license or permit issued by their state. What states are those, Edwin?
Well, we like to call these states sort of the usual suspects. And whenever people think of anti-gun states, these are the states that are falling into that category. California, Connecticut, the District of Columbia, Hawaii, Maryland, Massachusetts, New Jersey, New York, Oregon, and Rhode Island. Pretty much the states on the West Coast, the states in the Northeast, and then, of course, there's the special case of Illinois. So why is Illinois special?
Yeah, so that's our honorable mention, Illinois. The state of Illinois, while they do not recognize any other state's license or permit for the purposes of generally carrying in public, they do have a narrowly tailored exception that you need to read and understand before traveling to Illinois. They kind of treat your license or permit, or they can treat your license or permit as kind of an extending the Castle Doctrine for purposes of possessing a firearm inside of your vehicle. Again, you need to read the law of the state of Illinois before traveling there, and for God's sakes, don't go to the city of Chicago. But outside of your vehicle, that law would not apply, so you got to use extreme caution. But so we got our list of states that don't recognize anyone. We got our honorable mention, the state of Illinois. Now we have what might be kind of a workaround. I won't call it a loophole, as gun grabbers like to call certain reasonable exceptions for law-abiding gun owners. But what is the closest thing, Edwin, we have to national reciprocity when it comes to maybe being able to carry in all 50 states?
The only people who would qualify for this are retired law enforcement officers and current law enforcement officers, in which part of the anti-terrorism legislation that was introduced in the early 2000s included giving police officers and former police officers with certain qualifications the ability to carry in all 50 states.
So you sometimes hear this referred to as HR 218 or Leosa, and that there's so much to go into that we'll have to make that in a separate video. But understand that our honorably retired peace officers or active duty police officers, there may be a way to essentially have national reciprocity in all 50 states. Now, we have to add this warning. Let's say you are carrying under the authority of Leosa. Going back to our list of usual suspects, Leosa is kind of treated like a defense to prosecution in these states, which can cause some real problems. And when we say defense to prosecution, what do we mean?
That means that under state law, an individual can still be arrested, can still be prosecuted for violating a particular state's weapons law. And then during the trial of this issue about whether or not the individual was in fact unlawfully carrying, they raise this issue, and the fact finder will then make a determination as to whether or not the person falls under the qualification for the federal defense.
Yeah, so in plain English, what that might look like is maybe a police officer from the state of Florida goes and visits New York City for whatever reason, they're carrying under the authority of Leosa. If they were to be stopped, they could be charged with a weapons crime under New York law, and at their trial, they would present the evidence saying, hey, look, I'm a Florida police officer, and I qualify for this federal exception, in which case maybe a jury would be instructed to find them not guilty, but that doesn't keep them from getting dragged into the system and kind of put through the system in order to prove that they qualify for this exception. So be very careful, especially know what cities you're traveling to and how they treat firearms in those cities. Now, there's one other big exception for our, we'll call these the usual suspects, gun hostile states, and it relates to traveling under the Firearm Owners Protection Act, 18 U.S.C. 926A, in which case they may have another defense to prosecution. And what are we talking about when we talk about travel?
Well, we're talking about the safe passage provision, which allows individuals to travel from states where they where they are legal to possess firearms, 2 states where they are again legal to possess firearms, but their travels take them through a state that is very hostile. Probably the most common example is, say, driving from Pennsylvania to New Hampshire. Pennsylvania, a very gun-friendly state. New Hampshire, a very gun-friendly state. But right there in the middle is New York, as we know, is a very unfriendly state.
Yeah, so we have 3 qualifications. The first is legal start and legal finish. And so to clarify, in this case, we're going from Pennsylvania to New Hampshire. Now, let's say you're traveling from further away, Oklahoma to New Hampshire. Well, whenever you stop, that's going to be your new starting point. So let's say you drive halfway and you stop in, I don't know, let's say you stop in Tennessee. You know, Tennessee would be your new starting location when you start your journey again. So you don't have to, you know, take a bunch of caffeine pills and drive straight through. But your legal start and legal finish is the first qualification. The next qualification is you have to be traveling, which we don't have a lot of guidance from the courts on what this means, but think about not stopping for anything other than what's directly related to traveling. Maybe you stop for gas, but not going on sightseeing tours, not stopping to see museums, not taking paths that aren't necessary to arrive at your final destination. So thinking about driving straight through. And finally, your firearms, they have to be carried in a particular manner. And what's that, Edwin?
When traveling under the safe passage provision, your firearms do have to be carried in a very secure manner, which under the law means that they are unloaded, inaccessible, or locked up and out of reach of anybody in the passenger compartment. And they specifically cannot be in the glove compartment or the center console.
So legal start and legal finish, unloaded and inaccessible or locked up, and not in the trunk of the vehicle, not in the center console or glove box, and you cannot cease traveling. So you got to keep going straight through, not taking caffeine pills and driving from, I don't know, Nevada straight to Maine. But whenever you stop, let's say you stop at a hotel or you stop at a friend or family member's house, that's going to be your new starting point when you begin your journey again. So make sure that you qualify for those 3 things. But again, going back to the same thing that we had in the problems that we have with Leosa, this is treated like a defense to prosecution in a whole heck of a lot of these states, so it doesn't keep you maybe from getting arrested, charged with a weapons crime. But at the end of the day, so long as you meet those qualifications, maybe you have this defense at your trial. But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video. And don't forget to question and comment below. And until next time, we're the Armed Attorneys.